Judge Merchan is expected to reread at least some of the 55 pages of jury instructions this morning, which jurors are not allowed to take into that deliberation room with them. More on why in just a moment. But here's what the instructions say. In order to find Trump guilty, jurors must unanimously agree he knowingly falsified business records to cover up the hush money paid to Stormy Daniels, and that he did so with intent to commit another crime. In this case, the crime of violating New York election law, which forbids a group of people from promoting a political candidate the wrong way or by what they call unlawful means. So what are those wrong ways or unlawful means? Well, the jury has a choice, actually, of three. One, that the hush money violated federal campaign law. Two, that there were additional business records that were falsified, including bank records. Or three, that tax laws were broken. Now, and weirdly, the jury does not actually have to agree on which of those underlying crimes were committed to reach a unanimous guilty verdict. I think I got it. They're supposed to go through this very same process for all 34 counts that Donald Trump is facing. So I'm confused a little bit. I'm sure you are. So here with us again, Caroline Polisi. She is a defense attorney and a lecturer in law at Columbia University. Oh, my God, I'm out of breath.
I'm confused, too.
55 pages of instructions. And why can't they keep this copy with them in the deliberation room?
I know. And let me tell you, as somebody who practiced in the federal system here in New York, where we do it the other way, you do get the jury instructions to come back with you, that's completely anathema to me. I'm shaking my head. I'm not surprised that they have been asked to have a reread of the instructions by the judge. This is how they do it in New York. It's common practice in New York State courts. Judge Merchan is hewing very closely to all applicable standards as done by the book in New York State.
So he lays out the law in these 55 pages, and it seems like they're taking two misdemeanors and rubbing them together to make a felony, right? It's complicated.
Yeah. Okay. So let me take you back to square one. 34 felony counts of falsifying business records in the first degree. That's a Class E felony in New York. What prosecutors have to prove is the underlying misdemeanor crime of falsifying business records in the second degree, which just is a regular intent to defraud. In order to bump it up to that felony count here, they're adding a second misdemeanor. They're saying it was done, the falsification was done in furtherance of a New York State election law conspiracy to influence the election through unlawful means. Here's where it gets even more complicated. Those unlawful means, they have three options, right? It's like it's a smorgasbord of options for jurors. They can decide if those unlawful means were, one, tax fraud, Remember that true-up payment to Michael Cohen, the $130,000, the reimbursement. They doubled it for tax purposes. Little funny thing there, the tax fraud here is actually overpaying to the government, right? Giving them more money than usually think tax fraud, you think you're cheating.
Right, the opposite.
Second one is more falsification of business records. I don't really understand that one. It's there anyway. The third, which really is what the state is going for, is this FECA violation, right? Federal Election Campaign Act violations, the object of which is this Stormy Daniels $130,000 payment. They're saying that actually was an in-kind campaign contribution because it was made just days before the election, the purpose of which was to influence the election. It wasn't for personal reasons. Therefore, it's a crime.
Is there a chance that he could be found guilty of the misdemeanors?
No. So that's called a lesser included charge. Neither side has asked for that. They could have gone for that. They could have said you can choose one or the other. Not here. It's all the whole ball of wax they got to do. It's all or nothing.
And is jail time on the table here, or that's yet to be determined? It is.
It's on the table. It's also not on the table. So there's no mandatory jail time if he is found. Let's say he's found guilty of all 34 counts. Jail time is on the table up to 4 years. Doesn't have to be. I'm in the camp. I don't think he would serve any jail time. Likely more like large fines and probation.
All right, Caroline Polisi, we thank you.
Thank you.